Thank you.
I'm not going to tell you what their acronym is, but figure it out.
Will do.
Go ahead.
Chairman Huberty, members of the committee, thank you for this opportunity to testify. My name is Holly Wardell, and I am testifying in opposition to House Bill 1093. This is actually my first time to testify about any piece of legislation, so I beg your patience on this. I am here today as a parent of a child with a disability. I have one brother. He has Down syndrome. But for the last 22, 23 years professionally, I have had the privilege of representing school districts and educators all across the state of Texas in special education litigation, people who have dedicated their lives to working with children with disabilities on a daily basis. And so I have the unique perspective to share with you some information about the potential economic and financial impact of this bill. These due process hearings, well, let me first assure you that educators work very hard to resolve complaints that parents have regarding students with disabilities, but on occasion that is not possible. About 90% of these cases actually settle, 10% go to hearing, but let me put some numbers on that for you. The average cost of one of these due process hearings for the school district's defense is about $70,000, and that's if the school district prevails. If the school district loses, it has to pay under the IDEA the parents' attorney's fees, which can be anywhere from $80,000 to $200,000. This has been such a lucrative business for for attorneys who represent parents and students that attorneys are moving here from other parts of the country solely for the purpose of suing school districts. And no special ed funding can be used for this type of litigation. This all comes out of state and local funds. And so it's a very lucrative business. In fact, there was a firm that moved here from New York to open up a law firm in Austin for the sole purpose of suing school districts. They also have a traveling set of experts that they take around with them. And when we get to a due process hearing, it becomes no longer about what the parent was initially concerned about. It becomes what the attorney thinks they can make stick on the hundreds of regulations that we have under state and federal special ed law involving very squishy legal standards. What is appropriate for an individual student based on their unique circumstances, which is a moving target because they're growing and developing. By doubling the statute of limitations, you are doubling school districts' exposure, going to double their cost of litigation, and that is something that will come out of state and local funds. I'm happy to answer any questions that the committee might have, and I appreciate your time.
Thanks, Holly. Any questions at all for Holly? I think just a personal comment experience. I've dealt with this on a personal level with my children as well. I think that I think there's some school districts that have behaved poorly related to this over the years, and I think that certainly TEAs or the unnecessary cap or the cap that we removed last session. We're still seeing some concerns about that, and I think certainly from the state's perspective, the maintenance of effort that we haven't been doing. I mean, there's a variety of issues that's causing this issue to percolate a little bit better. So, and I think the one big issue I know that I'm not saying I'm for or against this, but I think I put this in perspective as you're a defender of the school districts that have millions of dollars to pay while the parent doesn't. To advocate on behalf of their kids. And I would love to see, I guess, depending on what happens with this, our messaging needs that our school districts need to do a better job of their special needs children. I don't think that it's gotten to the degree that I'm comfortable with it at this particular time, nor any other people. And so part of the new plan as we move forward is to provide those resources and increase the basic allotment so that that you can do a better job. And Representative Gonzalez is we're working on some mainstreaming ideas and things of that nature, because we do want the resources to be done, and we want these expedited. So because
yes, could I respond to 2 points?
Of course you can.
One being that it is because of the cap and the problem that has created, school districts are bearing the brunt of that. When we get a due process hearing, it's not the agency that gets sued, it's the school district. And they were simply trying to comply with TEA requirements. And so it's not fair now that school districts are getting penalized for doing what the state required, which is what's going to happen in the litigation involving the cap and child fine cases. Another thing I'd like to point out is that a lot of our rural school districts in particular, their legal budget may be $5,000, $10,000 the amount that they budgeted. They may have a fund balance of $50,000. One case like this could potentially bankrupt the school district. and exhaust their fund balance. So I just hope that the committee would keep that in mind.
I do, but also remember that, the backstop is the state and TEA as you continue to go forward. And so my message is that I think that in generality, I think school districts have been doing a better job, but I think it's proven through the variety of investigations and things that we've seen out there that some are not still. Right. And I'm just messaging whoever you represent, the reason you're seeing stuff like this is that the thought process as legislators, we only come once every 2 years, and we haven't seen the impact that we had expected. In fact, we had expected a bigger impact on SPED than what we're seeing, and we're not seeing it yet. So that's my message to you.
Thank you. I'm very proud to represent the educators of the state of Texas.
You bet.
Some
Thank
very
you.
fine people.
Jessica Whitty.